Va bene. Sì.
Allora, cominciamo. Bonjour à tous, seulement quelques mots en français, au mieux en italien avec un léger accent français, pour donner la bienvenue à monsieur Jean Lassègue dans sa langue, plus ou moins. Nous sommes vraiment heureux que monsieur Lassègue a accepté notre invitation. Merci infiniment pour être là, vraiment. Je suis particulièrement ravi que M. Lassègue est là pour plusieurs raisons, mais il y a une en particulier que M. Lassègue est le co-auteur avec Antoine Garapon dans le texte, je crois, les plus importants et les plus utiles pour entrer dans le monde de la justice digitale. C'est un livre vraiment très intéressant. Il y a beaucoup d'idées. Je voudrais souligner seulement une idée que je reprends de sous-titres. Le titre, c'est Justice digitale. Le sous-titre, c'est Révolution graphique et rupture anthropologique. Et il y a aussi une chose étrange, parce que dans l'édition italienne, ce texte a été publié. Le titre, c'est correct, la justice digitale, mais le sous-titre a été radicalement trahi et il est devenu déterminisme technologico et liberté. Je n'arrive pas à comprendre les raisons, peut-être il a eu des raisons au niveau éditorial, je ne sais pas, c'était un sous-titre trop intelligent, je crois, ou trop philosophique. Mais dans les sous-titres, il y a une idée que je voudrais souligner parce que c'est une des idées que nous avons utilisées comme cadre de cette série de séminaires. C'est le fait que quand on parle de numérique, on ne parle pas seulement d'un instrument, extraordinaire instrument, mais quand on parle de numérique, on parle surtout d'une nouvelle écriture. Ça veut dire d'un langage, ça veut dire d'une forme de vie. Et c'est ça la question. La justice digitale implique une vraie révolution. Ça veut dire que change tout. Dans notre façon d'écrire le monde, de le représenter. Et ça, c'est une idée que je trouve vraiment très intéressante. Monsieur Lassègue est chercheur au CNRS de Paris et directeur du laboratoire de l'Institut Marcel Mauss. Il est un philosophe et un épistémologue. Son travail a été dédié surtout à l'évolution des formes symboliques, à la critique des modèles utilitaristes en anthropologie et justement à l'anthropologie de l'écriture. Merci encore une fois vraiment pour être là. C'est une honneur pour nous. Maintenant, je donne la parole, passo la parola a Prof. Bondi, che è stato il nostro angelo mediatore, il était notre ange médiateur, ed è grazie a lui se il professor Lassègue ci onora oggi della sua presenza. Grazie. Grazie.
Grazie Alberto, ringrazio i professori Andronico e Faro. Prima di farò questa brevissima presentazione, veramente pochi minuti, in italiano, anche perché so che Jean Lassègue vuole vuole esercitarsi un po', quindi presento... fa parte del gioco. E, e quindi insomma la presentazione è molto breve. Vorrei cominciare solo con qualche ringraziamento, innanzitutto a Jean Lassègue di aver accettato il nostro invito, il seminario, i professori Andronico e Faro di aver deciso di partecipare con noi a questo piccolo progetto di incontri collettivi che riunisce più progetti di ricerca. Un piccolo progetto di ricerca di cui sono coordinatore, che si chiama Ecologia semiotica dell'attenzione, dove ci concentreremo in un ciclo di 4 incontri sui rapporti fra semiosi ed attenzione, in particolare in ambienti digitali. E cominceremo oggi con l'analisi dell'ambiente giustizia digitale. Ce ne saranno altri, per chi volesse posso fornire delle referenze anche informative per il resto degli incontri. Dopodiché volevo ringraziare il professore Marco Venuti, che è coordinatore di un progetto in partenariato e che ha anche finanziato l'invito del professore Lassègue. Il progetto è un progetto piaceri che si chiama Gioie. Gli acronimi sono molto lunghi: è giornalismo online ed emerging news. E poi volevo anche ringraziare naturalmente il Laboratorio di diritto e ringraziare anche pubblicamente chi ha unito e ci ha fatto incontrare, cioè il professore Marco Mazzone, che ci ha fatto scoprire questi comuni interessi. Fine dei ringraziamenti. Alberto, scusa, sono un po' informale come stile, quindi mi permetto di non dire il professor Andronico, ma dico Alberto ha presentato già il lavoro di Jean Lassègue. Aggiungo qualche altra precisazione. Jean Lassègue è direttore di ricerca al CNRS. Purtroppo l'istituto Marcel Mauss non esiste più, adesso si trova in posto al centro Georg Simmel, che è il centro di studi franco-tedesco, sempre all'École d'Hautes Études, quindi ha subito una piccola migrazione. È codirettore del seminario Chi l'a 20 ans, che quest'anno ha compiuto 20 anni, Forme Symbolique. Gli altri direttori sono io e la collega Valeria De Luca dell'Università di Limoges, un seminario che nasce 20 anni fa in seno a un'istituzione che ci ha visto lavorare insieme, che si chiamava il CREA, era il Centro di Ricerche in Epistemologie Applicate. Perché vi sto dando questo riferimento? Vi sto dando questo riferimento per presentarvi brevemente il lavoro di Lassègue dall'inizio fino a Giustizia Digitale e all'ultimo libro, che è stato pubblicato sempre con Antoine Garapon, quindi questa collaborazione fra un filosofo e un magistrato, che si intitola Le numérique contre le politique, il digitale contro il politico. Faccio girare anche questo. Il lavoro di Lassègue, che nasce appunto in seno al CREA, tiene insieme almeno 3 poli di ricerca che credo riuniscano i nostri interessi. Il primo è la revisione della storia dell'informatica, non da un punto di vista computazionale, ma da un punto di vista morfologico e dinamico. Cioè, Lassègue, rivedendo la storia di Turing, purtroppo non avevo a casa in Italia i libri di Jean, ce li ho a casa mia all'estero, su Turing. Un libro molto importante di Jean Lassègue consacrato a Turing è una revisione della teoria della macchina di Turing, non tanto come la prima esposizione alle teorie computazionali, ma al contrario come una delle continuazioni delle ipotesi morfologiche in filosofia della biologia. E questa riflessione, la faccio molto breve, vi do soltanto le coordinate, lo ha spinto a lavorare a poco su una nozione chiave che gli ha consentito di unire i suoi interessi per la storia dell'informatica, l'epistemologia e il diritto, e che era la nozione di forma simbolica che Lassègue ha ripreso dalla filosofia chiaramente di Cassirer, scusatemi, l'ho detto alla francese. Nel 2016 ha pubblicato un'altra opera che si intitola Dal trascendentale al simbolico. Qui faccio girare, se uno di voi può fare girare la traduzione italiana, di cui sono purtroppo autore, e attraverso la nozione di forma simbolica, e lì veramente mi fermo e chiudo, che Lassègue tematizza e ragiona su come alcuni tipi di tecnologie, e in particolare la scrittura, riescono non soltanto, come diceva Silvano Ru, che è una delle fonti, e Clarissa R. Schmidt, che sono due delle fonti teoriche su cui la SEG si concentra, a determinare una riorganizzazione del mondo sociale, ma in qualche modo aprono la strada e consentono di ripensare la stessa forma di vita digitale come nient'altro che una forma di rivoluzione grafica. Je pense que tu parleras de ça, donc je n'ajoute pas beaucoup de choses. Vi ringrazio e buon seminario.
Grazie.
Oh, let's go English now.
Okay.
Alberto and Tony have already said everything about the pleasure of having you here today. So let me just tell you a few words about this seminar, about the way we have imagined at the beginning this seminar. And when Alberto and I, as lawyers, decided to dedicate this series of seminar to artificial intelligence, we agree upon one basic thing, and which is that artificial intelligence is too serious an issue to be left to lawyers only. So this is why we decided to enlarge the sphere of both the speakers and the participants to the seminar. And I'm very glad today that we have this variety of discipline here. And we are very confident that you, Jean and Tony, next week will enlarge our perspective on the matter. So as the managing of the seminar, we have 3 hours time, but we are not obliged to take them all. So you are free to choose the time for your speech, 1 hour, 1 hour and a half, you are free. Then we will have a Q&A session, and if you want, you may conclude to have an early dinner tonight.
Okay, great.
Thank you, Jean.
Thank you very much to all of you for this great presentation. It's both a pleasure and an honor to be here. A pleasure because I didn't know Catania, so it's the first time, and I'm just amazed by the beauty of the architecture, and an honor also because I think we need these kind of sessions to, you know, try to mix various forms of knowledge, law on one side, computation on the other, and philosophy, of course. And as Tony said earlier, I started with epistemology and philosophy of mathematics under the guidance of an Italian professor, Giuseppe Longo, at École Normale Supérieure, who became a friend. We're still working together. And then I did work on the notion of symbolic form. I wrote a book on this, as Tony said, and I think it helped me understand the way the digital world is changing our forms of life in a very broad way. And what I needed at that time was a kind of red thread that could actually, at the same time, show the diversity of what is happening to us, and also the deep unity of it. And I think that the notion of computation as it is described today is not enough. we have to understand what computing is about. And as Tony said, computing is about writing, actually. So the models, the modern models of computation, especially built by Turing, or first Hilbert and then Turing, is very much a new step in the history of writing, in this very old history. And that's what I'm going to talk about. So I will first start with 3 points. I'm a philosopher, so my goal here is just to clarify the connection between law and AI. And I'm focusing on foundational issues relating computational literacy and legality. And I mean, this is something I will stress in this talk. I'm talking in front of jurists, and I will not dwell on legal issues concerning intellectual property rights, you know, copyright, industrial property, and so on. So, because of course this is something I'm not competent in. Of course, this is your business in some kind of way. And I will just start with the title of my talk, which is The Problematic Foundation of Law in the Age of AI. I think all the words are important, and of course, as a philosopher, I will be more interested in the problematic kind of viewpoint. Try to stress what is good and what has to be discussed again about the notion of digital legality. And I will first start with an example concerning justice. So when we think, at least when I say we, I would say philosophers, when we think of justice, I think justice requires a collective trust in various symbolic means. And I thought of 4 of them. The first one is very concrete. It's just the notion that the space has to be cordoned off. So it means that, you know, there is a space which is secular in a way, and then there is another space somewhere where we decide for justice to take place. And this is the courtroom. The second means is a specific distribution of roles. We have to make a difference between the accused, the plaintiff, the judge, possibly the jury when there is one. So we have to understand that these various roles can talk to one another. There's a set of rules, of course, generally written in our culture. It was not always the case, you know, from Germanic law in the medieval period was not really written. So this is also something really specific in Western culture, is the fact that we had periods where Roman written law was more or less absent. And there's a 4th means, which is a form of sovereignty, since the authority of the judge in a courtroom derives from a sovereignty over a territory. And the integrity of this territory is, of course, maintained by force. I think these are the 4 points that we need to get started in a way, to understand a bit better what justice is about. So I will also start with a quote by my colleague and friend Antoine Garapon in his book Bien Jugé, which is translated into Italian. I checked that. I made a little translation. To perform justice, one has to talk, testify, argue, prove, listen, and decide. For all this, one has to be placed in a situation where judging becomes possible. The first act of justice is neither intellectual nor moral, but architectural and symbolic, delineating a concrete space that would keep at bay moral indignity and public rage, managing an appropriate time, fixing a rule of the game, agreeing on the goal, and establishing rules for the actors. So I think this is an important way to start And, you know, and I will just stress the architectural and symbolic essence of the performing of justice. So, architecture, I will talk about my own city. This is the old Palais de Justice in the Ile de la Cité. Very, you know, there's a kind of awe in this kind of architecture. You have to be impressed. You know, you have to be impressed. You don't get into this building like, you know, in a cafe or in some kind of other place. You have a lot of stairs to climb, and you have a huge hall, and you are in a way awestruck in this building. The new one is also very striking, I think. This is the new Tribunal de Paris. The name was given by Antoine Garapon, actually, by Italian architect Renzo Piano, which is not in the Ile de la Cité, not near the river, but near the motorway in Paris. So that's the modern river. You know, there is something of a flux in front of the Tribunal de Paris. It's also a very awe-inspiring kind of architecture. When you are in front of it, you can't miss it. You know, it's really huge and impressive, and very beautiful as well. So now, if we get to symbolic, what is symbolic? Well, what's the most striking in a courtroom, I think, is the fact that here it's empty. You know, there's an empty space. So I think this is an important point. People will go to the bar and, you know, try to say something, and so there's some kind of dialogue which becomes possible. Another courtroom, this is Cour d'Assises in the new Tribunal de Paris. Also here a bar, also an empty space where people are gathered around. This is the same pic, same Cour d'Assises. Here, during the trial of the terror attacks of 2015, taking place in Paris in September 2020. So it's not as beautiful, and it's more like chaotic, you know. Police, of course, and lawyers, judges, etc., etc. But still, there is this empty space just right here in the middle. So, what is exactly a trial? My first definition would be a trial is a ritualized spatialization of conflicts, which means that in a trial, you have various things to perform in a way. The first one is the fact that, as I said, there is a cordoned off space. So it means that there is both physical distance and proximity between individuals and groups in conflicts. So we manage to put everyone in the same room, which is sometimes difficult. If I'm thinking, for example, of this very beautiful book by Yannick Enel, who wrote a book called Notre Solitude, not translated yet, I think, in Italian or in any other language, about the trials of the terrorist attacks of 2015. And he said that as a journalist, member of Charlie Hebdo, he was confronted to the very guys who killed all his friends, you know, in the same room. And this is something he had to stand for more than 2 months every day, you know. So that's certainly something important. There's also, as I said, a capacity for mutual speech given in turns by recognized authority, which is the judge. Sometimes in certain legal systems, the judge is in fact, I'm thinking of common law, is in fact just the one who can distribute the floor more than anything else. There is, of course, ways of evaluating conflicts given by a series of written texts, you know, Code Civil, for example, but many others, of course. And there's a search for a mutual agreement, ideally reached in a final decision so as to avoid private vendettas that can degenerate in collective violence. Of course, this is the main goal of justice, is to avoid collective violence at any cost. So the legal resolution of conflicts requires a social situatedness embodied in a ritualized spatiality. So this is something that is being disrupted by digital law. So I'm going to talk about this. This is, I would say, the normal way of thinking of a trial, but things will get more complicated when digital justice comes about. So if I think of what is the underlying conception of law in this presentation of what justice is about, I think I'm referring to the French philosopher Claude Lefort, who mentioned that in the modern political order after the American and the French revolutions is in fact a triple disincorporation, first of power, which means that the power is not embodied in a person, either a monarch, an emperor, or whatever. There's also a disappearance of a common good, because there is no more representation of an ultimate goal of society, as it was the case in the medieval period. And there is also a what he calls in French, desubstantiation of law, because law has no objective and precise content. Law becomes susceptible to change, to change rapidly, and law is independent of power, since there are now constitutions that last more than governments. So in modern times, the source of legitimacy is individuals only, and not what the French revolutionaries would call factions, groups in society. This is a very famous, at least in France, example, a law called Le Chapelier, who was a revolutionary who died under the Terror period 3 years after this law. This is what he says: there is no longer any corporation in the state. There is only the particular interest of each individual and the general interest. No one is permitted to inspire citizens with an intermediate interest, to separate them from the public affairs by a corporate spirit. So only individuals and the general interests, nothing else. So now, if I want to introduce digital justice, what would I say? First, some people would say it's just hype. It's going to disappear. I'm not sure about that. I think it's here for long, to last. It's going to last for long. So the basic observation that is made everywhere is the fact that today there are a lot of complaints about the slowness and the unfairness of today's justice. And the basic response is that technology can help improve the two issues of slowness and unfairness. Some people even claim that they would solve the problem through digital justice. So the basic goal is to put aside, in a way, the symbolic means and institutions at the foundation of the rule of law that I described at the beginning. And these symbolic means should be bypassed and replaced by technologically oriented mediations only. So this is what is new with digital justice. It's the idea that finally the symbolic order at the foundation of the rule of law failed, and now that we have these very complex forms of society, we need new instruments, new tools to tackle justice and its problems. So if I want to introduce, I will come back to that later, but if I want to introduce first remark on AI and computation, I will go back to Turing, a mathematician, British mathematician Alan Turing, who wrote in 1936 the first, I would say, a modern description of what computation is about. And the fundamental result of this article by Turing is here in blue. Sorry, I will go back if I can. Program, what we call a program, he wouldn't call it a program in 1936 because there was no computer, of course. But a program can be unable to answer a question, for there are questions that cannot be answered by programs. But when a program can give an answer, this answer is always the same. So it means that Turing was able to make a difference between two kinds of problems in mathematics: those who can be computed and those who won't be computed ever. So there are computing problems in mathematics that cannot be tackled by computation at all. And we know that, you know, it's a fact. So automation becomes feasible in some kind of way for very specific answers. And of course, these, what is called answer in mathematics would be called a decision in law. So, you know, leaning on Turing's theorem of 1936, we can say that there are some decisions that can be made automatic. And this is, of course, something very new. So the basic goal of digital justice is to decide automatically when possible, or failing that, automatically provide help in order for humans to decide. So this, you see there's a strict correspondence between the way I presented Turing's theorem here, the case where the program cannot answer a question, and the fact that when there is a program, this answer is always the same. So the practical implementation of digital justice is a partial or a total delegation to a machine. What do we call by that? This is something we have to clarify. It's both a piece of software, so what we call now a program, or a simulation of trained or untrained neural networks. So depending on the problems that are analyzed, it could be either a piece of software or neural networks. So now, what are the basic problems of computer modeling in the case of justice? Well, first, the question as a philosopher that I want to ask is it the same case as mathematical logic? So are there problems pertaining to justice that cannot be solved through programming? Or is problems that, you know, jurists and judges face in court of justice is completely computable? And I think this is a very difficult question to answer. Very difficult, because there is at least a theoretical answer and also a more practical one. The theoretical answer is unless one can demonstrate that a question cannot be answered through programming, you can look for programs forever. You know, if a question is open, well, maybe there is a program, you know, and if you haven't found it yet, maybe someone else will find it. So there is a kind of dynamics in computer science. That means that either you can prove that the problem cannot be solved through computation, or you have to look for a computation, and this can last forever. So that's the two options. So the situation as of today is what in course? Well, there are now various pieces of software that are used inside and outside courts in order to speed up processes of justice. So the first complaint was, you know, the speed, the fact that justice is so slow that we have to resort to digital means. And of course, we are now used to use, you know, speed cameras on roads, you know, that are connected to automated fining system. So at least in France, but I suppose it's the same case in Italy, you know, you drive too fast and you get a fine, and no one actually looks at the fine. You can of course appeal, but the first round, so to say, is totally automatic and has been for years now. There are also low intensity civil conflicts, like, you know, wrong deliveries of goods when you order something on Amazon, or delays in transport when you take a plane or a train. And this can be settled via automated processes monitored by private companies or public organisms. So I will give examples of that. And there is also another use of digital means, which is the computation of probable outcomes in trials. You know, to settle a divorce, for example, this case looks like many others, so we know statistically that you know, there are some kind of compensatory allowances that you can ask. You know, there is a certain amount that you might find is correct. So speeding justice is not really a problem, I think. It's more the question of fairness, which is problematic. And why is it problematic? Well, because the use of software disrupts the deep connection that we mentioned at the beginning in the various presentations that were made between the construction of a ritualized space, the capacity to speak in terms, and the authority of texts as sources of legality. This was, you know, I would say, normal way of dealing with conflicts. And this is precisely what the use of software is disrupting. And why is that? Well, it's just because legality is partially transferred to software, you know, to lines of code, which are supposed to be trusted just like any other legal instrument. But, you know, let me notice that these new legal instruments have no certification from a legal authority. And that's a real problem, you know. How can you use these instruments without having certification from a sovereign authority? I will come back to that also. So I don't think that digital justice is just another legal instrument that can be added to the other ones, you know, because if we go back to the 4 requirements that I mentioned at the beginning, we will see that now the situation is very different. Requirements number 1, it was this 3-dimensional ritualized space that I mentioned. But lines of code, as you mentioned in the presentation, lines of codes do not pertain to the 3-dimensional ritualized space at all. You know, writing is not something spatial. That's a big problem. You know, the software is just dematerialized tokens that are not meant to be read like a legal text, but just to be computed. So that's the first difference with the previous situation. Requirement number 2, a specific distribution of roles. Well, pieces of software do not suppose a space of interlocution between humans, for they are neither situated nor case related. So this is also something that would, you know, that take us out of the courtroom in a way. Requirement number 3 was the set of rules, you know, but lines of code belong to computer languages and can model any type of reasoning of the type if-then, leading to automatized decisions. So the compulsory force of logical entailment does not derive from a legal corpus of texts and does not derive from its sovereignty. It comes from elsewhere. And the last requirement, number 4, was a form of sovereignty. But pieces of software are mostly private products, protected by copyright laws. And of course, these copyright laws make it impossible to have a look at what the software is about. You know, it's just, you're not authorized to have a look at that. You know, it's in an industrial product. So what all this make, in a way, is a despatialization of digital justice, which is just a consequence of the despatialized usage of computer code. So I would say that despatialization is one of the most fundamental feature of computer coding. And in the case of justice and law, we can see the immediate consequence, which is to despatialize the very notion of justice. How did this happen? You know, where does that come from? I think that there are 3 steps in this despatialization of justice. The step number 1 was, in a way, we had some kind of naive approach to the digitalization of justice. And we thought first that digitalization of justice was just an office equipment in courts. You know, instead of having typewriters, we would have computers, and that was it. And does it work? Yeah. In a way, it manages the law differently. And of course, we have an easier and quicker access to legal texts online. You know, I was preparing a PhD defense the other day, and I didn't remember exactly what were the rules. Well, you know, I went on Legifrance, and, you know, in 10 minutes, I knew exactly what was the procedure. And of course, it's so easy and so practical. I wouldn't go back to the old systems of, you know, looking at books, finding them in a library and so on. So there is certainly an easier and quicker access to legal texts now. And there is also an easier and quicker updating of laws, regulations, and technical norms online, because it's easy to change a line of code much more than a book. So there are new ways of processing data between parties. You know, one example is the smart courts in China for e-commerce. You have automatic summons to appear in court. You have automatic research of precedents. You have automatic collecting of evidence. You know, all of this is made through automatic processes. Okay, so the second step was a more prescriptive role for judicial software, bypassing specialized courts. And I think the motto of this period, starting in 2000, was Lassègue Cody's law. You know, law is not now contained in textbooks or, you know, voted in parliament somewhere, somehow. They are actually in the software itself, you know. And it's true that we have in courts many different uses of digital databases, for example, in jurisprudence. We have civil and penal proceedings in digital format. In France, at least, we can file complaints online. There are, of course, as I said, dematerialization of small claims and injunctions to pay, and also the possibility for the litigants to follow the progress of the procedures online. And since the pandemic, I added that. We also have video hearings, you know, prisoners would stay in prison, for example, and would be questioned by a judge, etc. This takes place through the internet. So this is very new. And of course, all now, you know, the various pieces between parties are exchanged digitally. So that was in court, and outside courts, you have many companies now, you know, who are working on dispute settlements. If you think of eBay, for example, they have developed their own online settlement tools. You know, they manage to deal thousands of cases of conflicts between people. But you have also arbitration platforms like Virtual Magistrate, eJust, Netcase. And there are also things that we don't think of at first, like certification process. You know, is it me who's making this noise? Or should I use this? Okay. Is that better? Yeah. Okay. I will stay like this. Yeah, I was thinking of the work of bailiffs and notaries. You know, I was once invited by Belgian bailiffs who suddenly realized that that there was now an app on telephones that you could use when you have, for example, a car accident. You know, you can take a pic of what happened, you send it on the cloud, and it's the proof that, you know, there was an accident. It costs 3.5 euro. You know, just think of how much it costs to call a bailiff and to make a full report of an accident. It's like 350 euros. So the bailiff said, help, you know, we're going to lose our jobs. You know, what do we do? And I said, well, maybe you could go online yourself, you know, and make the app so that things can stay in your hands in a way. There are also automatic drafting of notarial deeds, you know, especially multilingual contracts. I've seen that, you know, French contract that would be translated into Chinese law almost immediately. And there is also, as I said, risk analysis tools before engaging in a trial. You know, am I going to lose? Am I going to lose a lot of money, etc.? And so you can use software. I'm thinking especially of case law analytics, of French legal tech firm that does exactly that. You know, so this is something that happens today. You know, it's not tomorrow. It's today. And there's a third step, which is difficult to describe because it's very much in the making, which is blockchain justice. You know, so legal decisions that are now carried out on secured networks using blockchain protocols. You know, so blockchain protocols were used for Bitcoins and other digital cryptocurrencies, but it's also used in online justice systems like Kleros. That's the platform I've been looking at, but also Aragon and many others. So this has, you know, its own problems of the fact that there is no central governance, which means that nobody can really take a decision on this network. Immutability, the fact that something is written in a block and it cannot be changed, but if there's a failure at some point, it's very difficult to change things. And pseudonymity, no personal identities are involved, but how can you really make justice without individuals or individuals that can hide their own identity? So this is also, I think, very problematic. So the question I would like to raise is, can justice do without spatiality and its necessary situatedness? What we can see these days is a transfer of legality from the spatial and linguistic order to a non-spatial, non-linguistic, only written one, which is based on computable lines of written code in which humans are supposed not to interfere. So I think there is potential conflicts between these two forms of legality, the juridical one on the one hand, and the computational one on the other. And I will briefly describe these conflicts. So step number one, if we go back to my example of justice, what about the specific phenomenology of courtrooms? You know, well, I talked of this awe-inspiring architecture, the fact that the courtroom is a public and advertised event, the fact that parties are confronted in a shared space, and the fact that, of course, there are many ritualization leading to the recognition that the legal order is above all the parties. You know, it is not depending on any party. So this is what disappears in digital law. So step two, what about the idea of reaching agreement through law? Law, I think, becomes a constraint among others in a risk assessment process. So law has not, you know, this above kind of structure. It's more a constraint that is to be taken into account among many others. Step three was about reinterpretation and enforcement. I'm thinking of issues in blockchain resolution protocols here. And there are, you know, a list of problems that I can think of. First of all, difficulty of appeal. You know, if a program is made to actually repeat exactly the same answer with the same data, what do we do with the appeal? You know, the very notion of appeal disappears. There's also a problem with the recourse of testimony. You know, speaking in front of a jury is a way, in fact, of reducing complexity. You know, you ask someone, well, what do you think of this? What happened then? You don't have to read thousands of lines of texts. But if you have only digital texts, and if you don't call, you know, witnesses, I think there is a potential deluge of digital documents to take care of. And that's a real issue, because this would, of course, make trials much longer. You know, there is also a judge one day told me that there was also a problem for judges today when they are confronted to only digital texts in various conflicts. It's the fact that they have to have some kind of narrative thread. They have to think, well, this happened and it went there, and from there it went there. So they have a kind of narration that they need to have. And it's very difficult to have only keywords to do that. You know, you just poke in these various digital texts, and it's even more complicated now to have some kind of idea of the story in a conflict. And of course, the last point, which is, I think, very important, is the question of pseudonymity that I mentioned already. How do we have means of coercion? You know, how do we enforce an execution, the execution of a decision? You know, anonymization makes enforcement very difficult. So now, this despecialization of justice, is it in par with the modern conception of law as described by Claude Lefort? I think it goes in the same historical direction as the three features that I mentioned. You know, I mentioned this incorporation of power, disappearance of common good, disubstantiation of law, and despecialization goes in the same direction. But what I think is that it reintroduces factions, something precisely that modern law managed to eradicate in some kind of way. And this is, I think, totally unheard of since the modern revolutions of the 18th century. So this is really something new that is happening. So if we think of these factions, what I call invisible factions. I will tell you why in a minute. I think that politically, what we call GAFAM in the West and BATX in the East are basically fueling social dissensus. And why is that? Because platforms are new marketplaces avoiding regulations, as you know. If we think of Amazon, for example, so there are many ways of tax optimization, evasion from labor laws that are put in questions. Social networks are directly influencing democratic deliberations. We know there are scandals of also platform in Italy that know certainly better than me, and also foreign governments are interfering in elections. It has been proved now by a computer scientist in France that the American alt-right in French presidential election of 2017 interfered in the last 48 hours of the second row. That's now an established fact. It's also the case with Russia Today. As you know, Russia Today is banned now from the European Union since the beginning of the Ukrainian war. And there's also something that I think is reintroducing these factions in society, which is the very notion of a sociological group of computer and data scientists that I compare to the scribes in antiquity. We can't go without them. Of course I can talk to you now, but I mean, some of our colleagues are listening on the internet, and of course it means a kind of technical feat that is just incredible, but we need them, and we can't do without them. So these modern scribes are making things very different from what the situation we come from. Because of course they can both enhance and also disrupt the rule of law, as any technology is neutral, so it can go both ways. And of course, from a geostrategic viewpoint, we of course know that we are very pleased to be able to talk to a friend in Japan or in the US just like this. So we have the impression that distance is completely abolished, and it's true in some way. But we can't forget that space is still at stake, in various conflicts, and we know that, of course, because of all the remote attacks and the cyber war which is going on now, that is affecting not only economic life, but also public services like parliaments and hospitals. And I also mentioned the viral scapegoat mechanisms, which are very primitive forms of justice on social networks. So there is some kind of primitive law which is going on these networks. So it remains a crucial geostrategic issue to control space, but that's not what the user will see. My children told me when the Ukraine war started at the end of February, but Dad, we thought that these kind of conflicts were over. This is cyber time now. But no, it's not exactly. Space is still very much the issue. So where does this situation of splitted space comes from? So if we go back to AI, we have to understand that it is the computation that really is splitting up the space into two, as I try to show you. So this is the second part of my talk, second and last part of my talk, and it's about computation and what is the kind of machine that we call a computer. So first, and if we take the notion, the history of technology and what is a machine, I think there are two types of machine. We think immediately of the motion machines, motion types, cranes, potters, wheels, carriages, boats, cars, etc. They move through space. That's the most classical kind of machines. And they require an external force to operate. But there is a second type of machine, what I called a token machine. And these token machines only read and write tokens. And there are writing systems, abacus, slide rules, and they require neither movement nor force or energy to operate. And they can become truly automatic machines. So I think that automaticity started there, not in the motion machines, but in the token machines. And this is what I want to stress now. But I want first to say that the computer is something very special because it's both a token and a motion machine. It's a token machine because it's only an automatic number processing alphabetic element combining token machine. It's a writing and reading machine. This is what Turing said in 1936. It was the first time he would describe what we now call the Turing machine. And this Turing machine is just a reading and a writing machine, nothing else. And this is what makes computation. Okay. But in the case of computer, which are the embodiment of a Turing machine, which was just an abstract infinite machine, actually, we managed to embody this token machine in an electric motion machine, just like this laptop. And this is quite a feat. We managed to make this reading, writing process a reality, a material reality. So what I want to insist on is something that my colleague at the CNRS, Clarisse Schmidt, once said in one of her book in 2007, which is that digitalization is the latest stage in the very long history of Western literacy. So this is something very new and a bit strange in a way. And the last slide here, I was talking about machines, token motion machines and computation. And now I'm talking about literacy. What is the relationship between computation on the one hand and literacy on the other? And this is what I would like to show you. So, as you know, in the Western world, we have been writing for 53 centuries. If we start the Western world in Mesopotamia. So I will not try to sum up 53 centuries in a quarter of an hour, but I will just stress 3 particular steps that are important when we want to make a connection between computation and literacy. The first step is what is called abjad, which are the 4 first letters of the Arabic alphabet, at least in the classical way of presenting it. So this abjad appeared around minus 1850, probably among illiterate Canaanite mine workers in Sinai. And as you know, it's exclusively a phonetic interpretation of Egyptian hieroglyphs. So there is no more iconic resemblance between icons and things in the real world. So that's the first, I think, the first stop of the connection between writing and space. And an abjad consists in writing down syllabic patterns, mostly limited to consonants, as you know, in Semitic languages, Hebrew, Arabic, and many others like Phoenicians, the writer only writes consonants, not vowels. But from the point of view of computation, this has a very important consequence. It means that one must know the language orally first before being able to read and write a sentence. So if you don't know Arabic, for example, well, you can't even spell out a single word. You know, you can't do that because you need to put the vowels at the right place. And if you don't know the language, well, you just can't read. That's all. But this is precisely which is different with the alphabet, the Greek alphabet. So the Greek alphabet inherited writing from the Phoenicians, which was an abjad, but it totally changed the way it works because now vowels and consonants were written down. And so what happens is the reading, the act of reading, is only the phonetic scanning of vowels and consonants. And there is no semantic interpretation whatsoever. Just think of you when you are tired and you're reading a page. And at the end of the page, you would say, hey, but what did I read? I didn't read anything because I didn't remember anything. What I did was only scanning. So there is a way of scanning the Greek and Latin alphabet, which is completely automatic, and it doesn't involve the semantic interpretation that you need to put, for example, the vowels at the right place in Arabic. You know, in Arabic, for example, you know, if you take KTB, you would put the vowels kataba, it means library, kitab, it means book, katib, it means the writer, etc., etc. But if you mix up the vowels, I mean, the text doesn't mean anything anymore. So there is an active part in the reading process, which is completely abolished here with the Greek alphabet. And my take is to say that we inherit in the computation process the very notion of scanning that appeared with the Greek alphabet here. So with the Greek alphabet, the reading becomes automatic. So I think that the Greek alphabet is the first automatic token machine in Western writing systems. So that's something important. So now if we go to code, the last and third step that I want to comment, well, if we have a quick glance at the history of mathematics, we see that there was a big revolution that goes from geometry to computability. My former professor, Giuseppe Longo, wrote beautiful articles on this. So geometry was always considered as a norm for mathematical space. Geometry is the norm of mathematical space, okay? But then there was a crisis during the 19th century, the end of the 19th century, because new geometries were discovered. Non-Euclidean geometries, but these geometries were contradictory with one another. So what was the right one? How could we describe space since Euclidean geometry was not the only one anymore? Hilbert, the German mathematician, had a way out of this problem. And he said that some kind of certainty could be regained by reducing geometry to arithmetic. And that's what he did. So the theory of space, geometry, lost its normative role as the source of theoretical intelligibility to the benefit of arithmetic. Now, the question is, where does this arithmetic necessity come from, of course? And how can we rely on arithmetic? Well, it became necessary to prove that arithmetic was coherent and didn't lead to contradictions, okay? So Hilbert used a new strategy, and this strategy was that arithmetic, in fact, is written with characters that can be listed in an alphabet. So when we scan the formal text in mathematics, we do nothing else than using an alphabet, only typographical marks or tokens. And of course, the connection between these typographical marks can be monitored in a purely deterministic and mechanical way. And this is what computation is about. Computation is nothing else than scanning tokens, nothing else. And this is what Alan Turing proved in the article that I mentioned in 1936, where he devised this new machine called now a Turing machine that could answer certain arithmetic problems that Hilbert mentioned. And there were some very unexpected consequences of this. First, as I said, there were some intrinsic and unescapable a priori limitation to computability. So this is something we shouldn't forget. There are limitations to computation. So if there are limitations in mathematics and also in physics, but I won't dwell on that, why not in the social sciences? Why would be the social sciences a word entirely computable if in mathematics and in physics we encounter problems that cannot be solved that way? The second consequence is that computation can be implemented in real machines, computers in finite size, this laptop, for example. And so, of course, computer programming was making computation automatic. So now we are faced with the very notion of computer programming. What kind of problems can be programmed? I give you just one quote from another Turing in 1950. He said, "Mechanism and writing are for me almost synonymous." I wrote an article on this very sentence with Giuseppe Longo. So it means that the writing had become partially automatic through computation. So it means that people are not the only one to write nowadays. Machines write also. So this is very important. And we understand now why there's no wonder why digitalization of law has lost space as its most basic foundation, because no code writing is out of space and has a role in the very definition of what law and justice are about. So what are the consequences for justice and law? Well, I think that first of all, the digital law has become partially illegible for citizens as well as professionals. I can, of course, read Légifrance online, but I can't program the texts. I have to use a computer software I can't program. So I'm completely dependent on people to help me on that. And the law itself is the computer code that I can't read, and nobody can, nobody can read. Second thing is that digital law is no longer written in full by legal professionals, but it is partially written by software itself. And this is very much the case with blockchain technology. So if we want to study the anthropological and semiotic consequences of this transformation of legality, I think we have to go back to this new way of reading and writing, and to put it in perspective, in the perspective of the history of literacy in general. So basic anthropological questions. Why do we crave for automation? Why do we like to delegate to machines? Where does that come from? Why do we try to delegate tasks to machines? This is an anthropological question. Some societies around the globe just don't care about machines. So why is it so important for us? What I can say is, as I showed, it's a very old tendency in the Western world to use linguistic science automatically. You know, it comes from abjad, from the Greek alphabet, and from computation. The second thing I can say is that it is highly expansive vis-a-vis the other writing systems, because if you take, for example, Chinese characters, well, you can say that they haven't changed for centuries, and in a way it's true. But in order for a Chinese to write a text message, well, it has to be computerized somehow. So it has to be alphabetized at some point, you know. So I think that today, all the writing systems of the world are in fact alphabetized at some point, not maybe, you know, on the screen when Chinese people look at their screen, but behind there is some kind of automatic process that is connected to the history of the alphabet. And the third point that I would like to stress, and this will be my next slide also, is that this desire for automation that comes from so far in our past has generated a methodological thinking since the Industrial Revolution. So I will just, you know, I made a very short list. I'm sure that some of you would add many other names in this list. But of course, since the beginning of the first Industrial Revolution, we have had this kind of mythology or dream about the independence of machines. So it can be Frankenstein, novel by Mary Shelley. I was thinking also of Erevan by Butler, but also films like 2001: Space Odyssey, or Blade Runner, or Minority Report. In all these cases, you know, we have the artificial construction of human beings, and we don't exactly know anymore where is science and where is science fiction today. When you listen to computer scientists, it's sometimes very puzzling to see that they would say, well, of course, this is not possible today, but it will be possible tomorrow. So they, all the time, they use a kind of proleptic figure of rhetoric, you know, what is not here today will be here tomorrow. So why not consider that it is possible today? You know? So I think that AI, in many respects, is blind to the fact that numbers and letters, of course, formal letters, are meaningful only because there are cultural tokens, and they pertain to the anthropological domain. You know, so when Turing proves something about computation, it does that on signs, and sign is not given in nature. You know, it's a very cultural product. So I think this is important to remember. For humans, meanings are not set of data only. They have expressivity in themselves, and perception is very much involved in that. So if I want to go a bit further than Claude Lefort, not that I would have some kind of genius idea about politics today, but of course Claude Lefort died before the time we are living, the digitalization of the present world. But I think that computer automation lets believe that the dispensation of law is complete, you know, and it is not the case. It cannot be complete for a very simple reason, is that we are bodies, we are speaking bodies in a three-dimensional world, and this is something we have to take into account. And the myth of computer automation also let us believe that written signs are automatically produced without human intervention. But in the end, there is always someone who writes the program. You know, we can't forget that. So it obscures the fact that signs are the product of human interaction and labor. So I think that the task for us today, and I think this seminar is certainly a proof of that, is that we have to clarify the social labor, which is the social labor of producing written signs, so as to regain some kind of collective space. Because if we want justice to be made, and if we live in a three-dimensional space, we have to find a new way of perceiving a three-dimensional dimension of space. So I will give a few, tentative solutions for regaining a sense of space and community. First of all, I think that there must be some kind of collective participation to the making of algorithms. So I don't mean that judges have to become programmers. I mean, judges have, are very busy. So I don't think that's a. But I think that in a way, this is more an educational problem. I think that we need to be more literate, digitally literate, and this is of course something that has to take many years, but this is something many people are working on. The second thing, I think, at least in a courtroom, is the fact that we have to agree at the beginning what is to be delegated to software. So, using software is not automatic and shouldn't be. All the parties involved should declare, well, okay, this part of the trial maybe can be automatized. We have the software, we all have the software. I think this is a very important point. I was discussing that with Tony. I think that in European courts of the European Union, if we use software, we should use the same ones, not one party using one because I would say they are richer than the other party. We should have, public domain kind of software that everybody can use. The third thing, which I think is very important, is what I call runaway effects. It's having a software is sometimes like I could compare it to driving a sport car. If you press too fast, you go too fast. So there are biases all the time in databases that have to be limited. So we need control over database and the way these databases are constructed. There is a very famous example that jurists know, which is the software called Compass in the US. I don't know if you've been, yeah. So you know what scandal happened with Compass when people realized that Compass, which is a software of liberation on parole, would keep in all African Americans and would liberate all the white people. So there was a big issue in the US about the use of this software. So we have to have a close monitoring of software, and this costs a lot of money. It's not only buying software which is a problem; it has to be kept at work. So, and it can go astray very easily if you change the database. So there is something here which is very important, which is some kind of continuing intelligence, so as to bring the results that we want with these kind of software. So I think that for jurists today, there are at least 3 steps that can be taken. First one is hybridizing old and new forms of law. We can't go from the kind of law system that we have to online systems just like that. I think the situation today is complex and needs hybridization, which means also that in law schools there must be programs that would mix up law students with computer students. I know that this is the case in France and elsewhere. I'm sure it's also the case in Italy. Of course, there are also, we have to find new ways of law enforcement, especially when we are facing pseudonymity and anonymity on networks. You know, how do we enforce the law? This has to be taken very seriously. And of course, we have also to promote ethical rules independently from the big tech companies, which have, of course, other interests, mostly profit, which is not a sin in itself, but it's just something that we have to deal with in the case of justice. And this means reinforcing accountability on algorithms, either by private firms or public institutions. I think that in a very short future, we have to set up, at least in Europe, a body of public commissioners that would control algorithms and finding ways to preserve business secrecy as well. So I think that we need a reform, a revision of copyright law today, so that at least some people have a look at what these software do. Maybe not everyone, but after all, you know, we have many commissioners who look at, you know, accounting and in our states. Why not having digital commissioners that would have a legal right to have a look at the software themselves? So I think this is what I wanted to say. This is the various books and articles that I used, and I'm open to questions. Thank you.
Thank you, Jean. I really think I interpret the feeling of everybody here if I say that this was really masterclass. I would have preferred to listen to you some more time, because you really have given us so many thoughts and inputs. Probably not all of them I can use it as they would deserve, because I have my limits as lawyer. But I would now ask the floor is if someone want to intervene. I think there are plenty of several profiles. Law comes at the end. But what you said in the first part about the linguistic anthropological foundation of extremely important. Please. I should ask you to come here, because otherwise no one can listen to you at home.
In what language? In what language?
Even Italian. But I won't answer in Italian.
I had, during your talk, I had two feelings. In the second part of your talk. My first feeling was that what Sylvain Roux called the third techno-linguistic revolution, the automatization of a language in a machine, was done. But my second feeling has been that probably this is not the case, because the point of the third revolution, according to Sylvain Auroux was not the implementation, the token machine, but was the implementation not of the writing system in a machine, but the implementation of a language, of a grammar in the machine. This means that there is no third revolution without the second revolution, according to Auroux. The grammatization of a language, the direct passage from the first revolution, writing systems, to the third revolution, it's impossible. Okay. Is this this second feeling of mine? Right?
Yeah, it is correct. So you are mentioning, or should I use this one? No. This book by Sylvain Auroux, La révolution technologique de la grammatisation. Yeah. So it had a great influence on me. I think it's a great book, really. I think you're right to mention that the question of what he calls grammatization is absolutely crucial. I didn't mention that here because I wanted to stress the if-then, so not exactly the grammar, the logical entailment, which is very central to computation. But to complete the history of automation, this step called grammatization is absolutely crucial. I agree with that. But I think it goes in the same direction as putting the rule and the logical rules in a language in some kind of written form, and that this written form can be then mathematized in some kind of way. You know, this is what Frege did, and this is what we find in mathematical logic. But I think you're perfectly right to say that what happened since the Renaissance was crucial, and it was the idea that finally natural languages could have new tools, you know, outillage, as Sylvain would say, and that this was a step towards this implementation of a written system of rules. Yeah, I quite agree with you. Mm-hmm. Yeah.
Okay.
Yeah.
Thank you.
Thanks.
Is there anyone?
How do you think that digital AI change law and IT, but in the short and long term? You already talk about blockchain and but in long term there is a problem of literacy, digital illiteracy, and that is a concrete problem. Do you think that we really can solve this problem in our society, in European society, because course, US and China are already more advantages in this problematic.
Yeah, thank you. So, in fact, there are two questions in what you said. First, well, second, you mentioned the fact that the US and China are more advanced in some kind of way. I'm not sure if advanced is the right word. I think there are three words, three regions in the world today, which is mostly the US, Europe, and China. And this is just because we tend to regulate usages, algorithmic usages in Europe. As you know, the European Parliament has passed various laws since 2020 about this. And European citizens are protected, which is not the case elsewhere, either in the US or in China. So I would say that, yeah, there are three blocks in the world today, and three ways of reacting with, you know, various cultures to this problem. So that's the first thing. The second question I heard in what you said was that can we deal with this new situation? Well, we have to, you know. I mean, we can't go back to. I mean, we use our phones and computers and networks, so this is the case, and it has started already. You know, I try to underline the fact that it was already going on. So now, can we have some kind of proactive attitude towards that? I hope so. I think especially that this is something that the European Union has been asking for. You know, the Parliament has asked the 27 countries of the European Union to actually have some kinds of commission that would discuss and make proposals about how to regulate algorithms at a European level. And this is done now. You know, there's been COVID. It took us time, etc. But it's very much now, these months. And I think that one of the things that would be absolutely necessary is what I mentioned, which is that we can't let some parties in trials use instruments that other parties can't use, because this is not equality before the law. So we have to do something about this, and of course European is the right level. Europe is the right level. So I think that there must be some kind of discussion in the next few months that would, you know, address the problem you were mentioning.
And you think that in the future the Estonian model is a correct model or not?
Well, they are very advanced in that, but you know, just think of the Ukrainian war. There's still space is still a geostrategic issue.
Estonia was attacked by Russia.
Yeah, of course. So there are now cyber attacks. Okay, so is it a model? Yes, if we put enough money to protect ourselves. But of course, this is this is very dangerous. But what can we do? You know. Right. Thanks.
Thank you very much for your very interesting talk. I'll try to make a question, although I'm very tired, and maybe I'll skip to Italian if I... Second part of your talk, the problems you mentioned about digital justice, and in the end, three suggestions about possible ways out of the problem. I think the first one is problematic, but you also said it is. But not only because, as you said, it is difficult that who is an expert in law is also an expert in programming, but also because today maybe programming is not the main way to digital justice or in general to simulation of the human abilities. The main way today, as you know better than me probably, is neural networks, is machine learning, is deep learning, and that stuff. So what I find really interesting is your third way, monitoring of what happens. You mentioned also cases in which biases in the data sets poses problems. Okay, that's interesting. What I want to ask is there any research today, or do you think that it would be interesting in case that some research that will be here about simulations with machine learning over human tendencies and biases? I mean, to use machine learning not to substitute human abilities, but to study human abilities.
Yeah, that's already the case, I think.
There is something.
Yeah. Especially, I think in Israel and in the US, where judgments of individuals is studied statistically in some kind of way. So, you know, a judge can have it, let's say his judgments or her judgments are out of the average in some kind of cases. And so if it's monitored, of course, I mean, there is something that can be done on this. And so it has two sides, I would say. There is a good side. So if a judge is racist or sexist, it would appear, you know, that there's something wrong with the kind of judgment that he or she gives. But the bad side, of course, is also that this judge could be summoned by his own or her own hierarchy to say, well, why do you judge not in the kind of average that we know would be more or less what everybody else does? So is it only courage, or is it something else? And this is, of course, very difficult to decide. So again, I think we are confronted to some kind of neutrality in technology. You know, it can help to have a better judgment, but it can be also, and at the same time, surveillance, a surveillance of what we consider as really sacred, which is the freedom of the judge to judge a case. So, yeah, this is a problem in itself. You see what I mean? Yeah.
I just sketch on your screen this new last week, because starting from Marco question, whether or not we may use algorithm to study people, it is as dangerous as well, because if studying means screening people through their ethnical origin or number of children, the part of the city where they live. Just a few weeks ago, in the Netherlands, some people receive tax requests for millions of euros just because they have big families, Moroccan origin. So it was presumed that they have frauded.
So yeah, I think it took several years, actually.
Yes, and
so,
the Netherlands is one of the country which is studying to have a digital commissioner. What you propose?
Okay, right. Yeah. And some people went to jail, actually.
Yes.
So it's, I mean, it's really serious. So that's what I mean by the problem of monitoring these, what you consider as a tendency. You know, you think that there is something going on in some kind of large scale, and then it can be just you know, artifact on the software itself. So we need to have a better look on what's going on. You know.
Very short follow-up. If I understand what you mentioned is again a way to use an algorithm to make decisions. But my point is, if you can use it to study how people make decisions.
Yeah. Well,
Okay.
Yeah. That's also something that is done. Yeah, of course. Yeah.
The risk assessment is a keyword because it's for Compass.
Yeah.
The case that you may go to have a crime again,
Yeah.
or an insurance company or a bank deciding whether or not to give you a loan. So
Yeah.
risk assessment is one of the keywords.
Yeah, absolutely.
About decisions,
Yeah.
judicial decisions. If I understood well, the question of computability.
Yeah.
It does not depend on the machine.
No.
It does depend on the object upon which the
Yeah.
machine operates. So
Yeah.
it depends upon the law, not about the machine.
Yeah, I mean, it never depends on the motion machine, on the motion level. It can only depend on the token level, you know. So it's a question of software, never a question of machines.
Yes, and I mean it depends on how the law is written.
Yeah, of course. Yeah,
We should think to a sort of mathematization of law, because only at that condition law can be scanned, as you said,
Yeah.
and read by an algorithm.
Yeah.
So
the problem is that as a jurist, you just can't read software, you know. So it means that legality comes from various sources. So if a community would agree on a software, it means that this software has been built both by jurists and by computer scientists, which makes things more difficult. Because of course, usually these communities don't have so much in common, and they need to have some kind of language that they can use. So there are many initiatives in Europe around this very problem. You know, how to make law or lawyers understandable to computer scientists, and it's a real issue.
Sì, sì.
Sì, io sono più bassa. First of all, when you talk about the space and the distance, I thought about the trial of Kafka, the book, because I think of the symbolic meaning of the space, and maybe in this book there's this importance, this space of the desk room, the courtroom, and it's beautiful to think about a writer who thought about it, and right now it's maybe disappear all of this because of the digitalization.
Yeah.
And I have a question about the concept of these of the interpretation of the law, because in all of these authorities of algorithm and that it's created by creators, by informatic creators, and maybe legislators and written laws. How about the doctrine, the jurisprudence, the interpretation, the act of the interpretation? Maybe the artificial intelligence could have its own interpretation, because we know that right now the algorithm can evolve, can create. For example, right now in another kind of object in Washington, Washington wouldn't recognize the copyright for an algorithm who create a work of art, for example. So how can these work with all of these evolutions and this computer courtroom, I think?
Yeah, thank you for the question. Maybe you had another one.
Yeah,
Okay, so
actually
I'll try to
a consequence, I think.
Okay.
How the token and automatic machine could calculate the categories of dollars, the behavior of parts, because parts cannot communicate, cannot talk, cannot seen in the face, maybe for example, in the blockchain trial. And so how can the machine calculate the intention?
Yeah, big question. Well, for the first part of your question, I would make a difference, but maybe because I'm a philosopher, but I would make a difference between in neural networks what we don't know, how the machine operates, and if it produces something original. I think that's two things that should be distinguished. I'm not so sure about originality in machines, I must say. I'm quite skeptic about that. Even if, of course, these neural networks, because they are more physical machines in some kind of way, although there are only models, because they simulate matter in some kind of way. They are more spatial, and so they produce results that are not exactly of the same type. Okay. This is a never-ending story. Neural networks were invented very early in the 1940s, and then disappeared, and then came back when there were more computer power, etc., etc. Well, maybe in 10 years' time, there'll be new theorems saying, well, there are also limitations in neural networks. I've read a few articles, heading towards this. So it's not a question that I would answer by yes or no. It's really some kind of work in progress. This is what science is about. There's no ending to that. So that's the first thing. The second remark I would like to make is about the second part of your question, and it's really hard to know. I don't think that we should start by saying that we delegate to neural networks and say, well, they compute better than us, or they make decisions better than us. I think that they are part of the social world, and as such, it has to be meaningful for a community. And so what they say, decide in a way, it has to be revised, understood, and maybe transformed by humans. But as such, we're not in Minority Report, and we can't be. It just doesn't mean anything. So that's why I mentioned the notion of hybridization. We have to make sense of these processes, and the problem is that because they are formal, they have no meaning. That's why they work so well. So we are those who can make them meaningful, and this is what you do as a lawyer, of course. But it means that the political dimension is also recognized, and not abolished as well, science fiction would show.
Thanks. I'm a lawyer, commercial lawyer. I would practical. I have been impressed by the first part that traditional justice. And not by chance have you Chiarr.mi as Excel post. And I think it's not possible to consider this kind of process as the prototype of the process. Because in any countries of the world, we have processes for administrative cases, for civil, commercial cases, and so on. And much more complicated is to say that we have not only different rules in law, but also different practices. Yeah. I mean, in criminal cases, the Chiarr.mi case receives an attention from the system, from the judges, from the press, from everybody, that is much more relevant than the case of somebody that does some minor crime. Yeah. The rules are different and the practice is different. Yeah. We never have in civil or commercial cases the parties standing there. I have heard a judge, not just one time, but frequently, looking at the parties, why are you here? Yeah. Please do not talk. If you talk, I will say you to go out. You have your lawyer. He will talk for you. Yeah. So it's something absolutely different from the idea of the Chiarr.mi case. I am there and I want to talk. I want to say my view. I want to say what happened. In many cases, you have no testimonies. Yeah, of course. Why? Because we know in commercial cases, for instance, the judges perfectly know that the testimonies go there to say something that is absolutely different from the truth. Yeah, or absurd. Okay. And psychology says us that independently from the will of the testimony, the probability that he or she says what is true is very scarce. Anyway, so it's better not to give room to these views that can only give false traces of what can be the truth. Yeah. Okay. After these premises, the comparison given between digital and traditional justice gives us the idea that with digital justice, at least with the digital justice as it is today, we lose something or much. You did not say this. Almost. And I don't know if this is your feeling, but this is the idea, at least I have given from this presentation. I would say this can be true with rules and the practice of the A processes. But we have also B, C, D, Z processes. Digital justice gives a strong push towards the truth in the cases of Z, T, W, and also B cases. Okay, yeah. And so right. I think that maybe it's very complicated too, because this B and Z processes are different from town to town, not only from state to state. Yeah. But the idea could be that we must distinguish cases that must be given to that scarce resource that is the human mind of good judges, and cases that can be left to the machine. This is the in my view, of course, I don't presume to talk for anybody, in my view, but this view is somehow somehow shared by many. We must distinguish. In many cases, the digital justice gives us an important advantage on what is the justice today.
Yeah. Can I say something about this before I forget?
No, I have finished.
Oh, okay. Okay. So because there are many.
Jenny, I don't speak so much.
No, there are many things in what you said. First about the Charlie Hebdo trial. Yes, of course. I mean, it's theater. You know, it's a big thing. Everybody wants.
And it is worth.
Yeah.
Scenario.
Absolutely. Yeah. It's a tragedy. It's a national tragedy, and we have to expel something. You know, that's for sure. So now, the problem I would like to underline is the fact that it is very difficult to make the distinction you make between an A trial and a Z trial, right? So
it's the problem of any borderline.
Yeah. Why is that? Well, precisely because it's the mathematical problem of computation. You know, there are problems that cannot be computed. Okay, let's forget about them. And then there are problems that are computable. So we have software, and that's done. And then most of the problems we just don't know. And I will take a very simple example, because one judge one day told me, "You're very optimistic about this digital justice. I will give you a very simple case. You have a neighbor, well, at least in France, in the Code Civil, if of your neighbor has a tree, and if the branch of a tree goes in your garden, you know that the fruits are yours, okay? But there are never-ending stories about quarrels between neighbors in France about this. And I said, yeah, well, okay, let's have an app. You know, you take a pic, and that's a proof, and up, it's done. It's speedy, and everybody agrees, and that's done. And then the judge told me, yeah, but if your neighbor has been annoying you for the last 15 years because he's also noisy and he puts you know, his refuse in front of your garden, etc., you just get mad at him, and this has to be taken care of by a judge, not by a machine. So even a very simple case like a branch that, you know, protrudes in your garden can end up in a very serious case.
Okay, but law is used in drawing this kind of lines. One can be the amount that is at stake.
Sure.
As example.
Yeah.
If the problem is not more than, say, 1,000 euros, the machine is enough. Like in Estonia, they
absolutely. Yeah.
The second point, depending from what happened, in case of economic damages for car accidents, without damages to people, this can be left all. And this is in Italy now more than maybe in Europe, more than 40% of the civil litigation.
Yeah.
If you take all these cases to the machine, you will have judges free to devote their time to the really important cases.
Okay, that's a very good argument. The thing is that usually, at least in France, I would say that the government would say, well, that's the good story. You know, judges will have more free time to have real cases. But that's not what's going to happen. What's going to happen is they will cut the number of judges.
This can be a good gain for the state.
Yeah.
Thanks.
But I completely agree with you. The problem is always how to make these differences, you know. And of course, there are cases, I mean, I mentioned eBay, I mentioned, you know, transport delays and things like this that can be absolutely automatically solved. This is a speedy way, and why not using it? So for this, I agree. But of course, as soon as the notion of witness, you know, or if you have to call someone to the bar to listen to him or her, it gets difficult, you know, of course. So I think that the old ways are still there, and for long, of course. But we agree.
C'è qualcuno, vedo ancora numerosi online, che vuole intervenire, può farlo nei soliti modi, alzando la mano o facendosi vedere con la telecamera, o anche parlando senza farsi vedere se vuole. Mi sembra di no. In aula c'è qualcun altro che vuole dire qualcosa? Alberto?
Diamo il tempo eventualmente a qualcuno a distanza. Non, je voudrais revenir sur la question de fondement. Parce que j'ai l'impression qu'on peut dire de fondement la même chose que Balthasar disait de l'enfer. Il existe, mais il est vide. Et que peut-être, pour revenir aux questions anthropologiques, vous parlez dans les bouquins avec Antoine Garapon d'une théologie digitale. Je trouve que c'est une expression très précise pour nommer cette question. Parce qu'effectivement, il y a une tentative de remplir le lieu de fondement, de comprendre le fondement. Et maintenant, cette tentative a été mise en forme par le nombre. Donc, il y a cette tentative de nommer par le nombre le fondement. Et donc, de nier le fait que le fondement est vide et que, je dirais, il doit rester vide. Parce que c'est vraiment très dangereux.
C'est l'idée de l'effort, en tout cas.
Oui.
C'est l'idée de l'effort qui doit rester vide. Le problème, c'est, à mon avis, effectivement, que la mythologie de l'intelligence artificielle voudrait mettre le nombre à la place de ce lieu vide. Mais ça pose toutes sortes de problèmes. Moi, j'ai bien l'impression que la déspatialisation, ça va dans ce sens-là. Ça va dans le sens d'un lieu vide. Et en même temps, ça coupe l'espace en deux. Ça laisse croire que l'espace reste vide, alors qu'en fait, en sous-main, il ne l'est pas. Il y a des factions, c'est-à-dire qu'il y a toutes sortes de logiciels qui permettent de tracer les gens à leur insu, etc., etc. Donc, le vide de la loi, à mon avis, est moins bien respecté autrefois du fait de la digitalisation. Et c'est d'autant plus curieux, c'est qu'elle se donne d'abord comme déspatialisation. Donc, on a l'impression que ça va dans le même sens que l'effort. Mais en fait, on voit que derrière, l'espace reste un enjeu et qu'il est travaillé autrement, par le biais des traces. Et ça me paraît très important et c'est très dur à comprendre. De voir combien ce divorce de l'espace en deux fait que le lieu vide de la loi est à la fois vide et pas vide. C'est ça que je dirais du point de vue des fondements.
Oui. Et une autre question, c'est que vous venez de dire qu'au fond, il y a dans l'imaginaire de la digitalisation cette idée, cette méfiance par rapport aux médiations institutionnelles, médiations culturelles. Et donc, il y a cette construction d'un accès direct au réel. Alors que c'est tout au contraire, c'est une façon de multiplier les médiations.
Absolument.
C'est ça.
En fait, c'est ça la grande théorie de la blockchain. La blockchain dit finalement, utilisons la blockchain pour éviter les nouvelles plateformes. Parce que les nouvelles plateformes ont recréé des médiations qui font du profit à l'insu des gens qui les utilisent. Donc, encore des médiations, trouvons le moyen digital, non pas revenir aux anciennes médiations qui sont dépassées, mais trouvons les moyens digitaux de faire en sorte qu'il ne puisse pas y avoir de reconstruction de médiation. Mais ça pose des tas de problèmes, en particulier dans le droit, puisque à partir du moment où il n'y a plus de forme de gouvernance centrale, il n'y a plus non plus de certification. Le problème de l'appel devient très très compliqué à gérer. Il y a toutes sortes de difficultés. Mais la question reste entière. Hein. Je crois que c'est peut-être une voie.
Ça devient toujours plus difficile à individuer en lieu de la responsabilité.
Ah, bien sûr.
Ça, Il y a un très grand travail pour la critique de l'idéologie.
Ah, complètement. Je suis d'accord.
Merci. Vai.
Va bene, allora grazie davvero di tutto questo. Credo che possiamo dare una laurea in giurisprudenza ad honorem, perché pur non essendo giurista in realtà è molto ovviamente addentro ai temi di cui noi discutiamo. Vi ricordo che mercoledì prossimo, o comunque il 27, avremo il professor Bondi qui presente, e quindi ci vediamo presto con i ragazzi della scuola. Grazie a tutti e buona serata.
Merci ancora.
Grazie.
Merci.
Arrivederci.
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 Arrivederci, grazie tante.
Buona serata, grazie.
Grazie, buonasera.
Arrivederci.
Arrivederci, grazie.